All right, Judge, he's on his way up. For your edification, this was a plea that we entered in front of Judge Angelini for 10 deferred.
Oh, no, I remember.
Okay, well, I'm just going to fill you in on what's going on there today.
All right, what's happening today?
So I asked the DA if he would be willing to consider the 10 deferred. He said, let me think about it. We did enter the plea fully and officially on the 4 silent. Mr. Hernandez then tells me he wants me to put it in a motion to dismiss for prejudice, and I told him there is no such thing because, judges bust plea bargains all the time. That doesn't give you a right to dismiss. And so then he says, well, he wants a jury trial. And I said, well, we have entered the plea on the 4 silent, so the judge may or may not allow you to withdraw your plea. And then that's what he wants to speak to you about.
All right. All right. We can go on the record.
Yes, ma'am. I just didn't understand what I was signing. And
Excuse
She
me.
hasn't
I'm
started
sorry.
yet.
I'm sorry.
All right. And let me stop you right there. All this thing where people say they don't understand what they were signing, based upon what is the information that I've received, that first it was 10 years deferred and the judge denied it. And then it came back to a silent offer. Yeah, everybody understood. Court is calling 2023 CR 10221, State of Texas versus Joe Hernandez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For the defense?
Suzanne Kramer.
All right. And are you Mr. Hernandez?
Yes, ma'am.
All right. A plea was entered in this case on, let me see what date is stamped on here, on April 22nd, 2024. According to the plea bargain agreement, punishments to be assessed at 4 years in the prison. There's a $1,500 fine, and the state is silent on the defendant's application. All right. With regards to the plea.
The tension in this courtroom is already building. What started as a routine sentencing hearing is quickly becoming a debate over accountability, treatment, and second chances. The defense is asking for community supervision instead of prison, arguing that Chelsea recognizes her substance abuse problems and wants help. But judges often look beyond promises and focus on actions. The big question now is whether her recent conduct shows genuine commitment to change or a pattern of missed opportunities.
Bargain agreement. The court, of course, does not have the PSI because we're coming back. Can someone tell me what his criminal history is?
Judge, I don't have the file on the
Basically, I could be off on this, but my memory is some minor misdemeanors and no felony convictions.
Mm-hmm. So, counsel, do you wish to have a PSI done, or do you wish the court to make its ruling?
Honestly, Judge, based on his criminal history, and of course, you don't have the benefit of the interview with him, but Mr. Delgado and Escobar and I can fill you in on part of the, I think it was part of this plea bargain too, was evaluation for Mick. There are definitely some mental health issues going on. You can tell by reading the report, but you do not have the benefit of having that in front of you. But I do feel confident, of course, it's up to him to go forward today.
All right. So I am reading the police report, and based upon the police report that I've read that are in the stipulation, there is documentation of bizarre behavior. And I don't know, based upon the police report, if that bizarre behavior was drug-induced or if there's some sort of mental health issues.
Which is why I think we had dual, right, with Mick, or was it just Mick?
I'm making yes, that was
I mean, based on my time, and certainly I'm not an expert in any way, but I would tend to think it might have been both, but definitely some mental health issues.
All right, Mr. Hernandez, you want to raise your right hand for me, please?
This is the first major turning point. The judge immediately zeroes in on a critical issue. If treatment was truly a priority, why wasn't it pursued when the opportunity existed? In sentencing hearings, timing matters. Courts tend to give significant weight to proactive efforts made before being ordered to do so. Chelsea is asking for leniency based on her desire to improve, but the judge appears focused on the gap between intention and follow-through. What do you think carries more weight?
Please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Joe Hernandez.
All right, so Mr. Hernandez, have you ever been diagnosed with any type of mental health issues?
No, ma'am.
All right. Not even in your childhood?
No, ma'am.
Drug use.
No, ma'am.
You're telling me you never used any drugs?
No. I'm an alcoholic, yes. I drink, but that's it.
All right, so in the stipulation, they're saying that you were exhibiting bizarre behavior.
Somebody was trying to take my life that night, and I was just trying to save my life. I was asking for help. And I didn't want to die that night. Somebody came at my door trying to kill me.
And I did.
And I ended up at the hospital. I called the cops. She has the phone record that I called the cops asking for help. I ended up at the hotel. I did everything wrong, yes. But I was just trying to save my life that night. I didn't want to die that night. I was just...
The courtroom dynamic just shifted dramatically. The judge is laying out a detailed history of missed chances, emphasizing prior releases, supervision conditions, and failures to comply. Even more damaging, Chelsea's attempts to explain her actions are being interpreted as proof of the court's concerns rather than a defense against them. That's a difficult position for any defendant. When explanations start reinforcing the judge's reasoning, the possibility of avoiding prison begins shrinking very quickly.
I didn't want somebody to take my life for no reason. That's the God's honest truth. And I'm here fighting this. I don't have mental issues.
Oh, I mean, if you want a jury trial, we'll give you a jury trial.
I'm 34 years old.
No, if you want a jury trial, you can have a jury trial. That's your question.
Or you can request the judge to give you deferred, and then that way you know that you know what the end result's gonna be.
I have a right to face my accuser, Your Honor.
Now, here's the thing, and this is what I don't think people understand. We can go off the record. Everybody thinks that they can be an attorney without a license. They want to throw around magic words like Jack and the Beanstalk. Oh, let me throw right to accuser, right to confront. Let me throw.
We're now approaching the most important moment of the hearing, sentencing. Notice how the discussion has moved away from treatment requests and toward compliance history, positive drug tests, and supervision failures. Those factors often play a major role in determining whether a judge believes someone is suitable for probation. Here's the question for viewers. Should courts prioritize treatment opportunities when addiction is involved, or does repeated noncompliance eventually outweigh the need for another chance?
I want a dismissal. The question is, do you want a jury trial? Yes or no? And let me explain something to you. If you say you want a jury trial, this train is going to a jury trial. This train is not at the last minute. Oh, I see witnesses walking in the door, so therefore I'm deciding to enter a plea bargain agreement. If you want a jury trial, court will give you a jury trial. You will get a quick, fast jury trial. So you want to discuss that with your attorney? You can. You all want to discuss that?
I'm good with the jury trial.
Do you want to discuss that with your client?
I think based on my conversation with him earlier this morning that he is, because of what happened the other day, it just took him off of pleading and he wants his jury trial.
All right. We're coming back on June 3rd.
Thank you, Judge.
And you will have your jury trial, and your plea deadline date has expired.
Thank you, Judge.
You're welcome.
May I approach, Your Honor?
Just one moment.
Yeah.
And state on Mr. Hernandez, I don't know if you all need to request that the stipulation.
The judge's decision is now official. 9 months in prison, with credit for time already served, along with potential post-release supervision and a future restitution hearing. Ultimately, the court concluded that community control was no longer appropriate due to Chelsea's criminal history and repeated failures to comply with court-ordered conditions. This case highlights the difficult balance between rehabilitation and accountability that courts face every day. If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
Be withdrawn, or you all can duplicate your steps.
I think we could do, I think Judge, I just do everything else.
Okay. All right. Thank you.
Off the record,
Yes.
I'm going to the New Plaza Club on Weston to find out. It's supposed to open up. I'm gonna find out what the lunches are about. I understand you love the chop chop.
Yes.
I don't think they have it. I'm gonna find out and I'll report back.
Yes. Do away with their chop salad.
because the world changes, Judge.
Yeah,
Yeah, you know?
yeah.
Okay, I'll probably text you.
All
let
right.
You know what's
All right.
going on.
Thank you.
Okay, thank you, Your Honor.